For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial has been completed, you are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I am not indicating any opinion about the value of that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may rely upon, after the trial, your notes will be collected and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony, because you must rely primarily upon your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice, if any is shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on the the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant the third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male, and to each of these charges as well the defendant has pleaded not guilty. Reckless endangerment of the first degree, as charged in these counts, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. A great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show